Welcome to this session where we are going to go through principles of elections, democracy, strategy for improving the integrity of elections, and will be taken by Mr. Moses Owol. Mr. Moses is an advocate of the High Court of Kenya and a consultant. He has previously worked for the International Foundation for Election Systems. He has also worked in the former Ministry of Justice, Cohesion, and Constitutional Affairs as advisor for the constitutional implementation. Currently, he's in the legal advisor to the Judiciary Committee on Elections as a consultant. Most welcome, Mr. Owol.
Thank you very much, Session Chair, and thank you very much to all participants. As we are settling, I hope we can embark very quickly to the substantive sessions after a very long session on the protocol part. So I believe that session set the protocol, and I am guided by that protocol, and I don't intend to repeat it. I've seen so many colleagues in the room. I've seen friends we've worked with. I've seen people who have been even mentors like Dorcas in the room. So I'm very happy, and we are in good company. I think it is one of the people who made the opening remarks said that we are not presenters, we are facilitators. And that means two things. One, at least some talking should come from you. It should not just be me standing up here to state or to go through my presentation. Secondly, we should have a common way of achieving certain objectives of the training. I'm very happy that the DPP, Office of the DPP has come up with a compendium on prosecution of election offenses. And I believe some of you are also building upon the experience you've had in this area. So we're actually dealing with subject matter experts. We're not dealing with greenhorns or people in the university that we need to give a lecture. As the session chair said, my name is Moses Owol. I've worked in this area, and I have a lot of pleasure in working around elections over the last, I believe, over 20 years. During that time, I've been in tally halls, I've been in polling stations, I've been in judiciary, handing election petitions, and I've had occasion to build some experience. So I want us to build on that and have a conversation around building a credible election process and also some common understanding of where we have come from. Part of my experience was on the former constitution. Part of my experience are also in the current Constitution 2010. And when we talk about the principles governing election management and integrity and strategies for improving election integrity, I believe we are talking about a number of things or general standards which we have learned over the years, internationally and locally. And some of the things we have explicitly stated in our constitution and how we understand them to build our electoral democracy. So I want us to have that, and I believe there are mics that will enable us to have some discussion on some of the common understanding. There are mics. There are mics and people who will at least share because I want us to, at least some talking should come from you as we proceed. Just to introduce this topic, I want to go through objectives, because time has also gone, of what I believe is this presentation should, and I believe part of the 4 days should cover. We need to appreciate our context, where we have come from, why we have settled on the framework and some of the principles we have explicitly stated in our Constitution, and why we think this is an important conversation to have. We need to understand the principles which govern our election system, and why we've set out our rules and our institutions the way we have. I believe that context is required, and that's why this presentation really is sort of a curtain raiser for the detailed presentations, which I believe will come in the next 3 or so days. We need to explain these principles and say and come up with some understanding on why these principles matter. We need to outline an overview of election integrity in Kenya and why we need clear strategies on improving election integrity. I believe we also need to have or to emphasize the need for institutional cooperation and complementarity among the key institutions. I think all the presenters in the morning and during had underscored at least one point, that they need to work across all these institutions. The DPP, the Electoral Commission, the Judiciary, NCIC, the Human Rights Commission, I think all of them had some commitment in terms of working together in achieving free and fair elections. And just to start us off, we have a broad spectrum of election offenses, which we'll discuss in detail in terms of elements, how to prosecute, how to investigate, and what institutions investigate. And in Kenya, we have, if you were to talk of a pyramid, you'll think of at the basic, the breaches of election code of conduct to the systemic violence that we had in 2017 and in 2007. So we've experienced everything. We've experienced people saying, people breaching or pulling down posters, which is among the most basic and the minor offenses, to an all-out or very close to a civil conflict over the last 10 years or within the last 20 years. So we need to apply ourselves that we are dealing with issues that can potentially break the very core of our democracy and our existence in Kenya. So we have all these offenses, and we need to we'll appreciate them in the next 2-3 days. So at ground zero, we can end up at 207, isn't it? So election can potentially take us there. At least we've experienced that. And therefore, these institutions, and especially the office of the DPP, then matters. Because when people start taking you seriously, when people start taking the IBC, the NCIC seriously, then we are thinking that the Constitution was designed with the hindsight of 2007 to establish strong institutions and strong processes for election integrity, that we can accept processes and participate in them fully and have confidence in the people who run those institutions. So why do principles matter? We are currently, as I said, I'm a consultant with the JCE, and we're currently running the training of judges. And one participant asked, why do judges need to learn about principles and the context? And you may as well ask, why do prosecutors need to learn? All we need to know is the elements of offenses, the evidence that we need to advance in court, and how to successfully prosecute, isn't it? That is the core of your mandate. But in elections, we are told principles matter, and we need to connect whatever we do to principles. So some of the reasons why principles matter is the constitutional background and context. We have had a situation within the last 20 years, we've reached a point where all these institutions were not trusted. People did not trust the courts, people did not trust, and we resorted to to self-survival. Politicians had their own security, they had their mongikis, they had their, what they call privatized security. And we ended up to systemic violence of the 207. So context and the constitutional principles are designed to deal with that possibility. Then we need to also understand that the Constitution itself has a historical and transformative agenda. I think it was Ezra Chiloba who talked about the transformation that all these institutions need to all the time think about the transformation agenda that we set off with the Constitution. Then we need to know that there's enhanced sophistication in election management. Within the last, in 2002, the election budget was barely 6 billion, perhaps less. Now we are dealing with over 40 billion for each election. We are dealing with enhanced use of technology. We are dealing with over 44,000 polling stations. We are dealing with hundreds of thousands election officials, 6 elections. We are dealing with more candidates than we ever did in the previous constitution. So there's a lot of sophistication, and politicians have also enhanced how they run politics. And the social media, someone talked about social media. One area that all countries are dealing with right now is how to regulate social media in terms of political mobilization, character assassination, and election and even in election technology. We also need principles, because whatever technology we have, we still have human involvement. Some countries are advanced and they use a lot of technology in terms of elections, but there's a lot of challenges even when they use technology. So there's always, whatever system of election that you use, there's always an element of human involvement, and we need to agree on principles and some element of code of conduct among people who run elections, and who prosecute those offenses and who adjudicate on the election disputes. Then how do we build, we then start on a conversation on how to build election credibility and integrity. That goes from not just credibility and integrity in terms of the finances, election budgeting, and political finance, but also integrity and credibility of the process. Then principles as benchmark for constitutionalism and accountability framework. So we need to have all that. So my presentation really talks about, tries to understand how these principles have had an expression in the Constitution, which I believe is a conversation that will be taken forward by the presenters, who will go to specific topics, specific offenses, specific institutional mandates, and electoral process areas. And of course, the IBC that will take us to the operational elements of management of elections in the part of the afternoon today. So why principles matter is also the values we have a constitutional obligation to apply ourselves to the principles. Article 10 says the values under which are set out under Article 10(2) must be complied with and implemented by all state institutions, isn't it? So we have a constitutional obligation to apply principles. Article 20, the Bill of Rights is enforceable and has, as a force of law in everything that we do. All state organs have obligation to apply themselves to the Bill of Rights, and in the decisions that they make, the policies which they make, and in applying the Constitution and the law. Article 20 of the Constitution talks about the implementation of the Bill of Rights. And then we also have the binding nature of the international commitments that we have. So we have all these as justification to apply ourselves to principles which govern elections, the principles which govern the protection of our democracy, and principles. So we don't just have the soft issues of our history and context. We also have express provisions in the Constitution that we need to apply ourselves and participate in the implementation of principles. And if a reminder needs, we need to remind ourselves, we need principles because of our history. We need principles because we have had occasions since multi-party and even before, where we have gone, where elections and political mobilization has struck at the core of our society and existence. And we have sometimes had investigated this through judicial commissions of inquiry, like we did in 1992 with the Kaloki Commission. We did in 1998 with the Akiumi Commission. We did in 2007 with Waki Commission. Is there anyone who worked in the Waki Commission? I don't want Odpp to answer this, or any of the commissions. I think she has experience in working in some of these commissions. Odpp worked in both Akiumi and the Akiumi one, isn't it? You worked in Waki or Akiumi? Oh, the Akiumi Commission, the judicial. Any prosecutor or anyone from the AG's office worked in any of the commissions, in the secretariat as a secretary? But you've heard of them, isn't it? Isn't it? So elections and political mobilizations have struck at the core of what we consider important in political transitions. So if you look at what we have gone through over each election cycle except 2002, we've had a lot of violence. And sometimes we've taken deliberate steps to investigate the violence. This is what Akiumi Commission said. Tribal loyalty and association seen in the 1992 and 1997 general elections as its roots in pre-independence Kenya. It was promoted and encouraged by colonial administration with a view to dividing indigenous people. Independent Kenya stands for unity among all ethnic communities, which unity should be nurtured and fostered. Consequently, we recommend that any person who directly or otherwise whips any tribal sentiments should be arrested, charged with appropriate criminal charges as a deterrent against repetition by him. So we know we need to prosecute, isn't it? We know we need to investigate. Whether we have over the last, since Akiumi report of 1998, effectively is a question that we need to know. And why, some of the reasons why we've had to even, strengthen the office of the Odpp, remove it from the AG's office. Some of them have their roots in some of the recommendations of these reports, that we need more independence, we need more power, we need more capacity, we need more resources, isn't it? So you are more empowered than a prosecutor, perhaps, in 1998. And I believe people who have had the occasion to work in both systems will tell you that you're far more resourced, you're far more sophisticated also in your preparation than these offices. So some of the inadequacies of these offices were also infrastructural, isn't it? Which we have strengthened using the law, but we have also strengthened using far better resources for these institutions. Just like Electoral Commission has a better budget and a better establishment right now, these other institutions, I believe, also have better resources and better establishment in the law and also in infrastructure. This is what the Kriegler report said, and I think this was a worse indictment to the AGs, and nobody would have dreamt, and if you know Kriegler, he has a way of talking in a way that can seem too blunt for certain people. Nobody would have dreamt seriously acting against people in high places. This is why they considered IBC did not prosecute, or the AGs did not prosecute, or the police did not act. Nobody would have dreamt of seriously acting against people in high places. The Attorney General certainly didn't lie awake all night worrying about all these crimes being committed, with not a finger being lifted to stop them. If the police were concerned about state affairs, they were certainly very patient. The ECK, with its powers under the National Assembly and Presidential Elections Act, the Code of Conduct thereto, and the Election Offences Act, which include powers to prosecute, never really beat anybody. Public opinion cheered on as it seemed to benefit the side they supported. So that these are all indictments, and why we need, this is what the CPEV report, the WACI report said, and I think you can read some of the slides. And some of the findings of the WACI report, I again, so they also attribute partly to our history. The post-election violence was attributed to historical and long-term tensions in conflicts, red spots that seem to have endured since independence, and intermittently boiled over to active violence, investigated in part by the Acumi Commission as well as the immediate trigger, perceived rigging of the 2007 December presidential elections. In conclusion, CPEV observed that the country must also make decisions to change the way politics is conducted, as well as to its intersection with other issues related to land, marginalization, inequality, youth. Short of that, violence, including that related to elections, will continue to reappear. So there's a warning that if we don't strengthen ourselves, if we don't live up to our mandate, we can as well go back to that cycle of 2007, or perhaps worse. You've seen political mobilization. There's that chance. Of course, we as Kenyans, we believe that maybe we don't have that chance. We have gone beyond 2007. But there's that chance if the institutions we have charged with greater power, greater resources, do not live up. And I believe that that is why this training and this preparation is necessary. And also the preparation of the commission, the preparation of the judiciary, the police, and other institutions. The constitutional transformation agenda is a key element of why principles are necessary. And this is really why, if you look at the cases which have been determined since 2010, there's a clear emphasis on constitutional transformation agenda by all institutions, including the judiciary. And what is constitutional transformation agenda? Especially if we are thinking about these institutions, the judiciary, and the decisions that we make. One meaning that has been proffered by a scholar is thinking of our mandates as a long-term project of the constitutional enactment, interpretation, and enforcement. So we don't just think of constitutional enactment and stop there. How you interpret it, how you apply it, and how you enforce it is a day-to-day constitutional growth, and thinking about constitutionalism and enforcement. And you don't think of all this in isolation. I think that's why sometimes politicians have not gotten in touch so much with the very robust decisions of the courts, whether it is BBI, whether it is striking down security laws, whether it is striking down laws on communication. So the objective is to transforming a country's political and social institutions and power relationships in a democratic, participatory, egalitarian direction. Transformative constitutionalism connotes an enterprise of a large-scale social change through non-violent political processes grounded in law. So we are not just, to a sense, even state institutions are activists of sorts. Our view when we worked in government offices is that activism is left for the NGOs, the ICJs, and all this, to tell us these nice things about constitutionalism, about respect of the law, human rights, and all these things. But the state institutions should just do their work and get on with their business, because we are busy, isn't it? We are busy prosecuting people, not thinking about the wider issues of transformation, the constitutional transformation. So all these are issues. Where are we transforming to? Where have we come from in terms of our election administration and management, and why is the need for transformation, and how should we look forward to transforming our election system? Is Kenya 60 years too late to blame that historical, you've seen the two reports. They blame the colonial heritage and also the history that we have in terms of some of the weaknesses. We've said we have still a young democracy, but are we too late in terms of blaming or not outgrowing some of the things we inherited from our heritage. For instance, if you look at the design of our political parties, just to give an example, between 1952 and 1960, we had political parties only based on regions. We banned national political parties, isn't it? Then the national political party started in 1959-60. Under the current constitution, if you look at the principles under Article 91 and 92, we try to really prop up our political parties and make them more political parties with national outlook, with offices across the country, national mobilization, not ethnic mobilization. But we sort of somehow still have political parties which are small, disintegrated, and which are almost in the line of 1952 and 1959 political parties. Because 1952, when the colonial government banned cow, national political parties were banned. So you had to mobilize within your district, isn't it? So one way of explaining why we have small, weak political parties is that history. But since we have, in Article 91 and 92, propped them up, in the Political Parties Act of 2011, given them much more capacity, including public funding, can we still blame that heritage? Or do we need now to build capacity among these political parties to outgrow that heritage? So those are some of the decisions. It's the transformation that we're looking at. So if you're making decisions or that affect political parties, you need to think of that transformation. Where are we going to? We are going to political parties with more national outlook, national mobilization, not ethnic mobilization, publicly funded political parties, accountable political parties with internal democracy and all this. But we have a history that explains some of the weaknesses we have of political parties. We need to know where the constitutional amendments that we had since 1963 to 2010 and the objects of 2010 Constitution. We need to think about the history of ethnic violence. Then 2010 as a seed of transformation. Then Vision 2030 as a pillar. As someone said, we need to think of 2022 as an election that will have a stable and where we can have competition based on issues. The values of constitutional transformation, these are well set out in our constitution. We need to, and if you look at the international principles, we start from the sovereignty and the meaning of republic under Article 4, the principles of representation under Article 81. We have clearer provisions on universal suffrage, right to vote, both under Article 81 and Article 38. Representative and accountable state organs, we've really propped our state institutions. We have perhaps a better informed citizens, and therefore public participation is very central to what all of us do. Rule of law and independence of the judiciary is important, and impartial civil service. One of the things you hear in our elections now is people saying that there'll be, you hear some people saying that the elections will be decided by what deep state decide, isn't it? Huh? Who is deep state? Is DPP part of it? Yeah? Who is deep state? Does anyone know the meaning of deep state? Any mic? I want at least one person to tell me what deep state is. Oh yeah, my friend from IBC. Do you know what deep state is, and do they influence you? Are you deep state? Do you have mics? I see someone is... There's a friend behind there who wants to tell us what deep state is.
It's a state that is deep.
I think it's just it's a faceless figure, so no one can really tell what is it. But what I can tell you, I work for IBC. Kunjiri is my name. Elections are decided at the polling station. Even me as a returning officer, there's nothing I can do. At the polling station, the presiding officer decides.
We'll come to that. I'm talking about deep state.
No, that's why I'm saying.
Yes.
Deep state, unless there's a deep state at the 40,000 polling stations.
So deep state has no role according to IBC. Is there a deep state?
Okay. Would say deep state is like a shadowy cabal. We know there's the president, the civil service, and everyone, and they do their role, but they believe that there's a puppeteer behind that is determining, not elected.
Thank you very much. You know why I'm talking about this is, especially the last three principles and pillars of election, you know, how we think about elections. When you are told to learn standards of assessing a credible election, one of the standards, we used to, apart from the management by the commission or by the election management body, you're told the three preconditions that you must have. You must have the rule of law and the independence of an independent judiciary. You must have an impartial civil service. And then you must have the other elements that, you know, a good electoral commission and all that. So in countries where there's clearly an impartial civil service, sometimes the civil servants run elections and people don't care. Because they know a civil servant, whether it is a mayor or, I'm not talking about the US here, because there have been a bit of debate in their last elections. But especially if you go to the Nordic countries, the Norways, the Sweden, all these countries, and even the former French countries, elections are run by their ministries of interior. People in this country know that between 1963 and 1992, we had elections run by the director of elections or the supervisor of elections in the Aegis department, which was not the time that we had independence of the civil service. But in countries where people trust the civil service, elections can be managed by a department of the civil service and people don't care. People accept elections because the ultimate standards of election credibility is an election whose result is accepted, isn't it? An election whose result is accepted, not by just the winner, but by the winners and the losers. So we need an impartial civil service. Whether they run elections or not, they will have some influence. They may be, it could be budgeting, it could be, you know, the police enforcing the law. The DPP is not the IBC, but you have a lot of work. So your work must be, one of the principles which must guard you is the impartiality. I've talked about Article 10 in terms of the principles now governing the Kenyan elections. Article 27 and 38. 38 is a Bill of Rights that govern the political rights, the right to vote, the right to establish political parties and participate in the affairs of a political party. And it's set out in that slide, and I think you can go through it. I don't want to restate it. Then we have principles governing elections proper. We have the principles under Article 81. We have the principles in sub B, which govern gender representation, the fair representation of the people with disabilities, sub C, universal suffrage. Universal suffrage is actually both in 38 and principles under D. We have free and fair election principles under sub E of 81. So if you look at our constitution from 81 to 87, they're generally the broad framework of elections. So that is how the constitution emphasizes principles. The old constitution, we basically established the commission, Then we set out the functions. We talked about boundaries delimitation and the offices which they are established. But in the current constitution from 81 to 87, we talk about principles governing certain aspects of elections. So the principles governing the election system are 81 to 87. We have 27, 38, 81, and 100, which a lot of it is about representation and how we do things like boundaries delimitation. We have the process of enacting electoral legislation. We mandate Parliament to enact legislation, which my colleague Conrad will go into detail in discussing our legal framework. Voter registration principles under 83, conduct of political parties 84, 91, and 92. Independent candidates, we now have a provision specifically allowing independent candidates, and then the voting system under Article 86. And if you look at 86, it has been legislated. It is one of the creativity or what we call the ingenuity of the current constitution to deal with some of the issues of election administration we had previously. It has been adjudicated, and a lot of decisions on it, like the minor KI decision is on the interpretation of 86 and Section 39 and Section 44 of the Elections Act, which are really to implement Article 86 of the Constitution. Then we have resolution of election disputes. What govern resolution of election disputes is Article 87 and the provisions on the judiciary, the independence of the judiciary, including the powers of the Supreme Court in relation to the presidential elections. Then we have the principles governing elections, that we will still have regular elections and the right to vote. We have, there was a speech that we talked about the date of election is now predetermined in the Constitution. So in Kenya, we don't postpone elections. Thankfully, we didn't postpone elections even in the previous Constitution. We've always had frequent elections as expected under international commitments and under our former Constitution. The quality of those elections is what has been debatable. But whether we have periodic elections as we have made the commitments, we've always had periodic elections since 1963. Then you also need to apply yourself to devolution and representation. So in terms of boundaries limitation, we need to apply ourselves to Article 89. And since your work is, the boundaries limitation disputes are not really criminal. These are just the principles that we set out, which you need to apply yourselves, we need to apply ourselves to, which I will not go into detail. The principles governing voter registration are under 38 and 83 that we have. For the first, the change from previous constitution to the current, we have a clear right of universal suffrage under 38 and 81. The right to vote is now explicit. We didn't have a right to vote. Of course, it was assumed, but now it's explicit. We need completeness of franchise. The voter register must be complete. As expected under Article 83, and must be accurate. And of course, if you look at the Elections Act and the Data Protection Act, we need protection of data of people who register as voters. The principles governing political parties, we start from the Declaration of our Republic in Article 4. The principles under and the values under 10 apply. We need, why political parties is important, if you look at the declaration of the Kenyan Republic, the way I say my name is Moses Owuor, Kenya is declared under Article 4, isn't it? What is Kenya? And if you read what is Kenya, Kenya is a multi-party state that respects the principles under, the values under Article 10. So we are first and foremost a multi-party state. So there is no, and it is a big deal because we had 2A before 1992, which defined Kenya as a one-party state and outlawed formation or mobilization through political parties. So that's why we state that, being a political party means something, or a multi-party state means something under our constitution. In Article 4, Article 10, Article 38, 84, 85, 91, and 92. And the Election Code of Conduct is also provided for both in the Constitution and the Elections Act. So this is one of the areas where some of us who work very closely with IBC, we have even say that perhaps it's an area that IBC may have a role that Parliament should not even oversee. Because it is a role, of course, Parliament says they must approve all subsidiary legislations. But if you look at the power of the IBC to enact or make the Code of Conduct, it's both under the Constitution and under the Elections Act. The principles and guarantees governing public participation, I think public participation is one key element that we need, and a lot of legislation and work of public bodies have been faulted by the judiciary just because of public participation. And every provision of the Constitution, all the principles, including principles under 132 governing state organizations, require sufficient information to the public and sufficient opportunity to the public to participate in the decisions that we have. The principles of election administration, this is the establishment of the commission, the independence of the commission, funding of the commission. Article 249 is important, Article 250 is important, and independence under the current constitution is very important because it's an element of protecting sovereignty. So we need to apply ourselves to all state, and this governs both the ODPP, because ODPP is also an independent state organ like the IBC. The appointment, composition and tenure, I think we have enhanced provisions under Article 250. We have much better secretariat of the IBC, in my view. Of course, this is my view, better resourced, highly qualified individuals, highly vetted commissioners compared to what we have previously. So how do we actualize independence, actualize this better resource to have the results that we hope for of better quality elections that will be accepted without drama and violence and offenses? We have the principles and guarantees of election operations, 81, 82, and most prominently 86, which require simple, transparent tax account of persons with a disability, accurate, the process of counting, tabulation, declaration of results, transmission, even integration of technology. We have clear provisions under Section 44 on integration of election technology, which is a prominent feature of our elections. The principles to guarantee dispute resolution. As I said, elections cannot be had without dispute resolution institutions participating at every element, whether it is DPP, the judiciary, and if the dispute resolution agencies are not respected, we end up to 2007, isn't it? So we need to have timely resolution of disputes, independence of the judiciary and other institutions, effectiveness of the remedies that we have. One thing that you may need to debate in the sessions that subsequent sessions. Under the former Cap 7, and we empowered election courts to have sort of the powers of the IBC in punishing election offenses, which we don't have currently under the current Election Offences Act. Those powers include the power to bar or to ban a candidate or a political party, and IBC has in the Code of Conduct those powers. The election courts don't have those powers currently because election offenses must be recommended. An election judge will only have a report to the DPP who takes up. Of course, for enhanced guarantees that are required under the criminal procedure and the Constitution to be available to people who are charged criminally. But we had one of the cases, which the famous Paul Ngei case, which was pardoned by the President Kenyatta, was by an election court who, after finding Paul Ngei to have committed an election offense, banned him from participating in the subsequent by-election. And sometimes we've had this power under the former law, which we have now removed. why this is interesting to debate is whether politicians really don't respect a lot of sanctions except barring them from participating in elections. That's why sometimes they fear the IBC, but they don't fear institutions like NCIC and these other institutions, which have some complementary mandates. Accountability of the judiciary, the due process guarantees that we have in the principles governing dispute resolution for elections. The principles governing investigation and prosecution of election offenses, we have, the DPP I think is doing much better now in terms of understanding, the compendium is a big tool, because one, you have to resource yourself, you have to equip yourselves. So independence of the DPP is a critical role. The principles governing national security agencies for investigation is critical under Article 238. The independence of national security organs, 239 and 242, are important. The decision to charge guidelines, including the guidelines which affect the DPP, and how you work with the IBC, the complementarity, because IBC has also elements of jurisdiction in terms of doing, investigating, and participating in the prosecution of election offenses. So introducing, part of my presentation was to give an overview of election integrity. I think all these processes contribute to election integrity. But there's an element of election integrity which addresses itself to financing and integrity of leadership, which is, sort of a leadership element of integrity than election integrity. So in terms of leadership integrity, we have, for election integrity, you need all this. You need the integrity of the legal framework, which we have talked about, and Bosire will talk about. We need integrity of all the processes we've talked about, integrity of all the institutions, integrity of the people, integrity people running elections, integrity and accountability of the process. Then integrity in terms of leadership is when you now talk about political finance and election campaign financing. Article 88, 4I of the Constitution mandates the IBC to regulate the amount of money that will be used by politicians and political parties in campaigning for an elections. That provision of the Constitution is implemented through the Election Campaign Financing Act of 2013. This act lies in the fate of the politicians since 2013. Why it was enacted in 2013? It was in draft in 2011 with IBC Act, Elections Act, and Political Parties Act. But they didn't enact this one when they enacted those ones in 2011, because no one wants to be regulated in terms of campaign financing. And this is common, even in very advanced democracies. That it was enacted late after the 2013 elections. In 2017, Parliament actually explicitly suspended its operations through an amendment in that act. Then in 2017, I think the IBC had sent regulations to Parliament, including proposed expenditure caps, but those ones have been suspended through, Parliament can exercise what they call the negative or positive resolution under the statutes for any statutory instrument placed before the National Assembly or the Senate. So they exercise by a resolution, they have resolved that the Campaign Financing Act or those regulations will not take effect until they will decide. So the objects of that act include establishing a framework for implementation of Article 88 4I, then regulation of donations and expenditure, prohibition of certain categories of campaign financing, transparency and disclosure provisions, and enforcement of dispute resolution. These are really the nice objectives across the world internationally in terms of campaign financing. They are debatable and widely contested in so many jurisdictions, and sometimes I will not go through that slide because I'm reminded that time has run out. So where do we go from here? We need institutional cooperation to promote these principles, and I believe the commitments that we had by people who made the opening remarks are commitments that will be followed up and joint processes taken, because there's a lot of overlap of mandates. There are processes where the DPP and the police, the investigative bodies have exclusive mandate. Then there are parts which the IBC have critical mandate which will overlap. And then there are also elements which the IBC, like election irregularities, the enforcement of their own codes of conduct where the IBC have exclusive mandate and roles. So there's a lot of need for complementarity and coordination. In terms of case studies, this is what courts elsewhere have talked about in terms of cooperation, in terms of implementing the enforcement and prosecution mandates. The European Court of Human Rights versus Romania, for instance, speaks about the need to have this complementarity in terms of complementing your resources, both the IBC, both the election bodies and the enforcement bodies. Then you have all these requiring institutional cooperation, all these provisions which give us powers. The judiciary has a role. They have gazetted the magistrates, and I'm happy that the DPP and the other organs will participate in the training of the officers. The IBC has been participating in the training of judiciary. Then there's where do we cooperate? We'll cooperate on developing enhancing our mandates through procedures, enhance cooperation in administration, enhance cooperation for referrals, and this is where you may need to have codes of conduct or protocols for referrals of actual cases, joint trainings, which we are currently doing, and of course, joint stakeholder participation and public education. These are more case studies in terms of prosecution, and I believe, I'm not going through the case studies because they're in the slides, and there's also a lot of opportunities, including people coming from other jurisdictions, which will give us clear case studies and their own experiences. Where do we go from here? In terms of prosecution of election offenses, I've talked about Paul Ngei. We know about Moses Masika Wetangula case, where we moved back to separating Election Offences Act from the Elections Act. And the cases like Kethi Kilonzo, where there's really this issue of complementarity and cooperation among institutions it emphasizes that. So these are areas that we need to think of as we go forward. We also need to think of the Mutual Legal Assistance Act to the extent that it can be helpful. And I want to ask, do we enforce the Rome Statute in our country? The Rome prosecution of offenses relating to, if assuming we don't stop at this ethnic mobilization, we reach the 207. Are we thinking of a situation where we are not telling people we go to The Hague, we have the capacity because we are party to these instruments? Yeah? So I think those are issues which you need to debate as you move forward. So because some of these issues we may need not to have them come, but within the next 2-3 days, I think these are issues which I'm just putting up there for discussions. Decision to charge guidelines, how you align them to election offenses. The due process guarantees, how you align them to election offenses. The Mutual Legal Assistance Act, how will you apply it in the election offenses context? The framework for prevention of violence and hate speech. There's a lot of processes by the IBC, including their work with the peace committees that you need to be aware of and participate in. So I want to end there. And there are some of the resources that I'll propose for your further reading. But some of these conversations will go in detail in the next presentation. And of course, I'll be open to questions during plenary.
Thank you very much, Moses, for that very well-researched presentation. You have taken us quite a lot. And I had to give you sufficient time because of what you are giving us is so important and so key. You have taken us through the historical background, even now to how we developed up to the new constitutional dispensation. Can we give Moses a round of applause? From where I'm standing, I'm seeing very tired people. Can we wake up for just 1 minute? We stretch a bit before the next presenter. Kindly wake up. What we are doing is so important because it will determine where we are after August 8th. Can you just stretch a bit and then we... Dr. Conrad, as they stretch. And please, those who are going, you also come back. I have noted your faces. Dr. Conrad? Yes, I'm here. Okay. Karibu, Dr. Conrad. I know you have taken a bit of time, but this is how important... oh my, was it a break, another break? Then 2 minutes. Nobody else is going out. Bonnie, you know your duty. Get all those people who have gone out to come back. I have the pleasure of introducing Dr. Conrad Bosire. He's an adjunct lecturer, Strathmore University School, Nairobi. Dr. Conrad holds a Master's of Law in Human Rights and Democratization in Africa from the University of Pretoria, South Africa, and Doctor of Philosophy, Law from the University of Western South Africa. Conrad doctoral research analyzed using Kenyan's new development system of government as a case study, how substantial government can, through constitutional design, pursue development, peace, and limited and democratic central government. Conrad is also an adjunct lecturer at the Strathmore University Law School, Nairobi. Karibu sana, Conrad. We are so eager to hear you. And I know each and every person who is present here will be playing a part in the coming elections in one way or another, not necessarily IBC, wherever they will be. So we are so eager to hear what you have for us. Thank you.
Thank you. Thank you very much. And it is indeed a great pleasure to be here and to have a discussion with you on this important topic as the country gears up to the election. Kindly assist me to put my slides up in this. The owner of the laptop, please help me to put my slides up. Huh?
This is your slide.
No, they are not. I sent it to Lillian.
To Lillian.
Yes. No. Okay, let me just see.
It must be in one presentation.
Okay. Is it here?
No,
It's not
here. It's not here.
Okay, I sent it to Lillian.
Lillian who?
Just 1 minute. We are working on it. He's downloading his presentation to the screen. Just said somebody else so that I can. That's tell us, however digital we have become, you must always carry a hard copy. Sorry for this, but we are now ready.
I'm sorry about that. I hope the slides are coming up, and I'd share them early. It's just I think they did not reach the laptop that is here. So, as I say, my name is Conrad Bosire, and I was requested to come and make a presentation. It will come up shortly, but it's in the program there on principles, the legal framework, and the institutional mandates. So basically, if you saw what Moses presented before me, there is sort of a repeat of those issues. And because of time, and I'm the one who is preventing you from your lunch, I will especially ensure not to repeat what has been highlighted in the previous presentation. But in forums such as this, what I tend to do is to just pose a number of questions for reflection. I am the least qualified person to teach you about prosecution of election offenses. You even have a manual about that, and I'm sure most of the cases there, a good number of people in this room prosecuted those and participated or even in the development and contributed to that. So I wouldn't really want to go into the technical details of prosecution of election offenses, telling you in a very dry and descriptive way this institution does this. IBC, the chair himself was here, and they explained their mandates much, much better. What I want to do for the next few minutes just before lunch is to pose a few questions for your reflections. Prosecutors, I heard that we have a number of institutions represented here, and elections actually give us a time to reflect as a country. We are told that elections help us to democratically choose leaders, that voters, those the most of whom want, then become leaders. We were told that decision is made in the polling station. Then you are also told that when we participate in elections, it is a project in nation building. We build stability, we become more united and prosperous, democratic nation. So, very beautiful theory. Are elections uniting points or dividing moments? Both. How can it be both? Anyway, I have a lot more questions for you guys to answer. So I want us to look at the Kenya election system management. Principles, my co-presenter has dealt with that a bit, so we'll brush over that. The legal framework, and then the institutional mandates. But before that, of course, these institutions, their mandates and everything happen within a context. And I think for purposes of these meetings, those contexts are important because they feed into what we do as professionals in our various capacities from the various institutions that we deal with. So those are some of the questions which you're going to look at: the context and background, constitutional values and principles, those we have dealt with, laws and regulations, stroke regional instruments, that is the legal framework that we deal with. We have national laws. By the way, in Kenya, we have no shortage of laws on everything, especially elections. Even now as we speak, Parliament is trying to change some, isn't it? So we have no shortage of laws and all that. And then at the national and the international level, regional, we do have instruments for that. Then we look at the institutions and their mandate in the election. And my favorite is questions without answers. We go home to think about them. Very briefly, I just want to go into the point because Moses has given us a lot of history. All that history that he gave us, I just pinpointed one particular instance where Kenyans decided we are going to change how we do things through the CKRC, isn't it? The constitutional review process. We know the processes until 97, until 2002, and the 2005 referendum failed. 2010, you got a new constitution. But if you check page 168, the Yash Guy Commission left a very comprehensive report, 700 pages. Just go to article 160, page 168 of that report. It gives you what we identified as challenges in the election. So, lack of proportionality, so they say that actually you can elect a president with a minority vote. 1992, 1997, the late President Moi won the national vote for president with 36%. So 60-something did not vote for him, but he still became president. And we said, maybe there's something that we need to correct there. That is why we have 50+1. Zoning off electoral areas, ethnic voting patterns, political party memberships. That time, if you looked at the political party memberships and lists, they said it looked like zoning off a country. And those are things of the past. We don't do that now, isn't it? Yeah, so we say that was a problem. I don't know whether it's still a problem. FPTP. FPTP in full is first past the post, isn't it? Where the one who garners the most votes, Odpp, is the one who becomes the candidate. Somehow we identified it as a problem, but again we ended up with it. Then we said that elections should be about development, about national unity, about agenda that leads to progress in this country. It should not be about ethnic maths. I hope we have moved from there, because we identified it way back. Then we said too many political parties, they lead to political fragmentation. We have bribery and patronage. At least in 2016, we said we make this an offense, and that's why we are here today to see how we can enforce some of that. There was gerrymandering and manipulation of constituency boundaries. I hope we stopped. Credible concerns about rigging of votes, and then of course election violence. We identified this back in 2005, and in 2007 we confirmed it's actually there. And in 2010, after the 2007, we decided we are going to have a new constitution. So in the committee of experts which followed the CKRC, I've put a quote there. The ECK, which Moses talked about, was so mistrusted that an entirely new body, the IIEC. If you remember, before IIEC, we had the IIEC, isn't it? Which was part of the accord. And because the 2007 commission had messed things so much up that we decided to come up with a new institution. But also, the post-2007, we jump-started the constitutional review process. You remember it had gone down. And as part of consolidating the political stability and managing the electoral process, and of course the fundamental reforms in 2010. So, just very briefly before we go into the institutions, we are not alone. In terms of organizing elections and everything, we are just one of the so many countries struggling how to make our institutions democratic, representative, and all that, and elections are in the middle of that. But what we are told is that elections have grown in number across the world. So we used to have an average of 30 general elections in the 1950s, and then towards 1990s, at the end of the Cold War, fall of Berlin Wall, now the world became more democratic, and we have more, around now 70 national elections held every year. The only place where this has not grown is in Latin America. Fewer elections in 2012 than in 1946. I don't know why. At your own time, you can Google and find out dropping elections in Latin America. But then we are told that overall, that 30% of elections around the world result in regime change. 70% yule mwenye alikuwa ndio yuko. Sorry, how do I translate that? The incumbent is still there in most of the elections that we have in the world today. It's not necessarily the case that elections must result in a change of regime, isn't it? The one who is there, and especially if you are in your second term, you'll defend. And if you are more popular, you retain. But that also tells you that this is where we are headed with these elections. But the other thing which I need to mention here, they say, there's a book which I relied on to get this. It's called How to Rig an Election. It's an ironical title, but if you go in there, they give a lot of good facts. They say that the proliferation of the elections, which I've just mentioned there, they have not coincided with democratic credentials. So you have elections taking place more and more frequently than ever before. But when you evaluate electoral democracy, the substance of democracy, and whether the activity of elections brings out democracy, then the authors say it's not really the case. And then the book which I've just mentioned, the authors there gave us 4 categories of democracies. So we have the pure authoritarian, no election. An example? Yeah? Uganda has elections every... The Electoral Commission will be shocked. You say they have no elections. One example? Huh? Sorry? China, the Communist Party. Yes, there is no election, but China says the Communist Party has the philosophy of the country. Closer home, which one did I hear? Eritrea, yes. The closest up here, they have never had elections. There's a strongman there called Isaias, who has never organized elections because he says he knows what Eritreans need. We have dominant authoritarian, so we have their example. Here, basically the authors say, you have elections, but the incumbent wins with 99% of the national vote. The examples are up there. Competitive authoritarian. Here, you go into elections, all of you, but the opposition, one leg is tied, so you have to skip instead of running like the regime. Any examples? Huh? Uganda. Well, you can say that now. At least they have elections, but it's competitive authoritarian, isn't it? Kenya. Kenya, who agrees? Are we there? Okay, there's the fourth one. Where is the electorally democratic? Okay. Please think about it. We may answer it or not. But the authors tell us that we are a competitive authoritarian like Uganda. That's what the authors say. The incumbent has more advantages, resources, campaigns, and then you try to use the law here and there to frustrate your opponent. We fall there. Then they say that electorally democratic, the US, UK fall in that category. You may differ with those categorizations, isn't it? Because in every system, you'll find there are challenges, and democracy is an ideal we aspire to without getting there. So if you look at the book which I was just mentioning, they mention how to rig an election. This is what people used to retain to be in office. All those old tricks, new tricks, and everything in between. But I think for our purposes, most of those are election offenses, isn't it? Yeah? So we can say that we have tried to control those through the Election Offences Act, which has a whole range of offenses. We have discussed a bit about the constitutional framework and the values. I don't want to go through that. Just to emphasize that as we prosecute, do these frameworks and values make sense to us? Article 81 and all those sub-provisions which Moses has kind of mentioned. I don't want to go through them. They are relevant for these discussions. So you start from the Constitution. We have the Elections Act. We have the Election Laws Amendment Act. We have the IEBC Act, Election Offences Act, which is relevant for this training, the Election Laws Amendment Act. We have the Political Parties Act and the Campaign Financing Act. There are so many down there. So the effects of a lack of inadequate enforcement of election offenses is clear. There is an organization called the National Crime Research Center. I'm sure you've heard of them, isn't it? And they did a research on election offenses, isn't it? So there, I got interested to look at and see what they say about election offenses, because it's one of the legal frameworks mentioned. And what is the effect? They say that it's a serious threat to the democratization process of a country. Offenses may aid the installation of leaders with unsatisfactory competencies and questionable integrity. The legitimacy of political system may be jeopardized if the electoral process behind the system is riddled with crimes and offenses, disruption of lives and livelihoods as a result of related offenses. So that is a research which documented things. It's some years back, but it has some relevant observations for us still. So sometimes what I battle with when you do research and you're coming to make a presentation is how to make this material useful. I'm sure you've seen some of the materials which you've referred to, the Constitution, you've read it several times, and you've done other courses on this. And looking at the history where the country has come from in terms of management of elections. We have the 2016 Elections Offences Act. Have we hacked it in terms of having order in the election process through effective prosecution of election offenses? Yes or no? And I know I'm asking the most qualified audience, the prosecutors here. So have we acted? Yes? No? Yes? Dorcas?
What happened in the last elections, prosecution of criminal offenses emanating from the Electoral Offences Act was with the IEBC. It is last minute, just before the last elections, that the mandate was transferred to the Office of the Director of Public Prosecutions. And by the time the mandate was transferred to the Office of the DPP, it was not commensurate with budgetary allocation to allow us to prepare on time, but we tried.
They help you create a link between the actual work that you're going to do and where it's supposed to lead us in terms of achieving the objectives of the Constitution with regard to free and fair elections and all that. And as we go forward, how do we find those systems of values are effective in the work that we are going to do? And now with what Dorcas has mentioned, I think the third question is very important. I'm sure you troubleshoot and see ahead, isn't it? As the prosecutors or even election officers from IEBC. Would you say that the current system, the way we run elections, the way we operate, embodies the values that Moses talked about? Yes, it embodies. No, it doesn't. Looking at it overall. Okay, we may not have to answer now, but at least in the background we know. And the question I'm posing here is, does the current system with its complexities enable us to carry out that function as prosecutors? Please, that's a question for reflection. So, is the lack of actual values in practice, if that is the case, an actual hindrance to the prosecution of cases? As prosecutors, now that you have the mandate, now that you have the resources, you have the trainings and preparations, how does a system that does not reflect the values which it purports to have, or it reflects, how does it hinder the prosecution process? And then, how do you address those challenges after troubleshooting? I can't wait to read the post-election reports of how the prosecution story went. But I think it's important to think about these things in order to prepare yourself for the work. So, I mentioned the initial list. There is a continuation of the legal framework here. I just stopped there to pause and say, what do the Election Offences Act? What kind of questions we should be reflecting on as we go into the election. So we have the Leadership and Integrity Act, what Moses dealt with just before he left the stage. Public Officers Ethics Act, Opinion Polls Act, Supreme Court, the big one with the big petition. Appellate Jurisdiction Act for processing of election appeals, and maybe even the offenses up the judiciary chain to the Court of Appeal. We have the County Governments Act, which deals with the county government elections. Then we have a flurry of legislation, subsidiary, that have parent legislation in this. The elections regulations, the general amendment, the elections voter education, party primaries, elections technology regulations. So this is also a list of regulations which developed from the earlier framework which I just listed. Beyond Kenya, Kenya has bound itself to some regional and international standards of free and fair elections, and there are some which are continental and very direct to our elections. Some are international under the UN treaty system, which we have committed ourselves. They all have a bearing. The African Charter on Democracy, Elections and Governance, and being one of the most specific ones, the Universal Declaration of Human Rights, where universal suffrage is actually one of the core provisions. All these tend to inform what we are doing in Kenya. When we were presenting this before judges, they said someone came to court and listed only these principles and said that the party that they were representing had all the rights in these instruments had been breached and wanted the rights from the court. I think after some discussion we said, you need to ground it in something local, isn't it? So if the international instrument has the right to vote, the Constitution too and the Elections Act. So I think the same applies to the prosecution process. I need not emphasize on the content of that. The other thing we are doing, we just amended the Political Parties Act to provide for some coalitions. We defined the coalition political party, and we have seen the major coalitions depositing political party agreements or coalition agreements. We know that is what the country is dealing with now. The debate on whether that is democratic or not, I think is for another forum, another day, and new and emerging information. So all these issues we provided for in order to manage political parties before the election, and this is the Political Parties Amendment Act. We have the bill 20, it's not been passed yet, isn't it? The election bill amendment, not yet, isn't it? It's still, we are very good people, we amend up to the last minute. Even the lawyers, the judges were worried that they might preside over cases on the basis of laws they have not understood yet. The ink has not dried from Parliament, so I'm also posting down there whether it's a good practice. So we have Codification of Jurisprudence from 2017. Some of it is in the Election Amendment Bill. We have provision of alternative transmission of results other than electronic to cater for areas with no network coverage. Amending Section 39 1C, so that we allow multiple ways in which presidential election results. This one was specific to presidential election results. Harmonizing the changes in the Political Parties Act and the Elections Act, because we are now recognizing coalitions as parties and all that. Timelines for lodging complaints with the IBC is also one of the issues they dealt with. So in brief, I've given you a list of the laws, regulations, and the ongoing amendments which are being made to the law. So very briefly about the institutions. We have the IBC, which is the Elections Management Body, the Dispute Resolution Committee of the IBC. We have the Office of Registrar of Political Parties Liaison Committee, the Political Parties Dispute Tribunal, to which some of the cases are taken to and not to court. I'm sure in the training we'll deal with the extent of jurisdiction for all these bodies. These are the main ones that we know when it comes to elections process. Then we have, of course, state institutions, security, very important. So the security organs come in. EACC comes in, Parliament with the laws that they are trying to amend. Executive to provide us resources to carry the elections. And when we don't do it well, or at least some don't think we don't do it well, then we go and quarrel in the judiciary until we have an agreement. Then this also extends to non-state institutions. We have civil society, accountability, monitoring, and voter education on all the civic governance processes that those institutions support. We have media with its role, private sector with their roles in the process. So basically those are the institutions, and I need not belabor the detailed functions and responsibilities that these institutions play in the elections process. So I want to end with some 4 questions. Again, as I said, I love questions that throw us back to reflect a bit. And why do we have to frequently change the election laws? Make changes to the elections management body almost with every election. Moses, when he spoke here, he referred to the Kriegler report. One of the things Kriegler requested us to do is to have stability towards the management of elections, isn't it? Actually, what he said, let members of the elections management body come in at least 2 years before the election so that they are conversant with the procedures and all that. Did we do that this time? Last election? No. Since Kriegler? Okay. I think some of these recommendations are legitimate. We have the Elections Amendment Bill in Parliament. I think, in my view,